Hi, my name is Jamahl Kersey. I am a criminal defense attorney in San Diego, California, and I wanted to shoot this video to give a background for some of the future videos I'm going to be recording. So I'll be going into the specifics regarding individual crimes and the defenses that can be used in order to defend oneself against those charges. But I think it's important as a background to explain the elements of a crime and how prosecutors get convictions in order to make those videos make a lot more sense. So I had previously recorded a video regarding how charges get filed, and that had to do with everything from the investigation of criminal activity or alleged criminal activity by law enforcement up until the evidence being transferred over to the prosecutor's office, them reviewing the evidence and then determining what charges, if any, would be filed in court. So then the next step would be analyzing, okay, well, how do prosecutors secure convictions? So there are two ways that a person can ultimately be convicted of a crime. Number one would be that person pleads guilty to a crime, and number two, the person goes to trial and gets found guilty either in front of a judge or in front of a jury. So in front of a judge would be, it's a bench trial that doesn't have a jury, or typically you would have a trial in front of a jury in front of 12 people who would ultimately decide, after hearing all the evidence, whether a person is not guilty or guilty. So the way the prosecutor seeks to prove somebody is guilty is by introducing specific crimes, and then they have to prove what are called the elements of a crime. And so the prosecutor having the burden, so they have the burden of proving beyond a reasonable doubt that each one of the elements have been fulfilled. If they're not able to prove that each one of these elements have been fulfilled or are true, then the jury or the judge has no other choice but to find the person not guilty of the crime. And so to illustrate that point, we can take, for example, Penal Code Section 211. So Penal Code Section 211 is the section for robbery in California. And as its elements, robbery has the taking of the property of another using force or fear. So in order for a person to be convicted of a robbery, they would have to take someone else's property and using force or fear. All right. And so take that as compared to a mere theft, which would be, the taking of a property of another with the intent to permanently deprive. So if they did not use force or fear, then that would be a mere theft versus a robbery, in which case the person would have used either force or fear of force. And so your classic example would be someone sticking someone up in the streets. If you have a gun in your pocket or something that looks like a gun or some sort of weapon, and you point in the person's back and you say, hey, give me your money, that would be an example of a robbery, because if they were to take that person's wallet or money or jewelry or what have you, then they have taken the personal property of another and they were using force or they were using fear with that weapon that they had, or the threat of using a weapon or what have you. So again, the prosecutor, in presenting their case before the jury, just using this example, they may call the alleged victim as a witness who would say, all right, I was walking down Fifth Avenue, it was dark outside, an unknown character came up to me and I felt something, some sort of hard object against my back, at which point the person told me, listen, if you don't give me your wallet, I'll put a bullet in you. And so I proceeded to take the wallet out of my pocket, or I took the wallet out of my purse and I gave it to him and he ran away. All right. So that would be the testimony amongst, other evidence that the prosecutor might have at trial, that the prosecutor would then ultimately argue that the elements of those crimes were fulfilled because you had testimony that there was a taking of the property, so the wallet or the cash, jewelry, what have you, and it was accomplished using force or fear of force. And in this situation, that was the use of a gun or an object believed to be a gun being stuck against the person's back. All right, and so this is the context we're talking about trial. So the other question would be, well, how does a person decide whether or not to plead guilty? And so generally that's going to be on the advice of their counsel, whether that's a private attorney or a public defender. Before a person decides to plead guilty, the defense attorney is tasked with explaining to the person why it is in their best interest to plead guilty, because generally speaking, the judge, prior to allowing the defendant to enter his guilty plea, he's going to say, well, did you have an opportunity to speak to your attorney? Did you guys discuss any and all potential defenses? Did you talk about the law? And after that, he's going to say, having been satisfied in terms of the explanation of the law and any defenses and whether or not they apply, is it now your desire to enter a guilty plea? And the person would then have to affirm. If there's any hesitancy or it seems as though the defendant does not want to enter a plea, then the judge will say, you know what, let me give you more time to sort it out with your attorney so as to ensure that when that person decides to plead guilty, it is knowingly and voluntarily. So those are key trigger words, that any plea needs to be entered knowingly and voluntarily. In other words, it needs to be with the knowledge that that is within the person's best interest. He knows what he's getting into. He knows what time he's potentially facing. He knows any and all defenses. He knows of the evidence that would be presented against him if the case were to go to trial. And then the other part, in terms of voluntarily, that plea is being entered with no threat to him or his family or anyone immediately close to them. So ultimately, in order for the defense attorney to guide or aid the person making the decision, that's when the defense attorney will go through with the client the evidence that would be presented against him if the case were to go to trial. So let's say, going back to our robbery example, typically in a case like that, you would have some police reports. There would be witness statements. I'd say at a minimum, the alleged victim would have given his statement to the police. I already kind of set forth the factual background, but that's what you would see in the police report. The police would have written out a report indicating, on such and such date at so and so hour, I had an interaction with this person who told me that they were walking down the street. An unknown person came up to them, pushed something hard into their back and told them, give me your money. And at which point they complied with the request, and then the person ran off. All right. And so you may have witness statements. There may have been other people, this is Fifth Avenue, perhaps it's a busy street, and those other people saw it as well. And so they were able to say, yes, I saw somebody dressed in all black. He was about 6'5", medium complexion, long stringy hair, and I saw him, running down the street. And maybe other witnesses saw the exact same thing and were able to give statements to the police. Perhaps because it is a busy street, there were neighboring businesses that had surveillance cameras. And so the detectives go to those businesses to see if there's any surveillance video that might help them in their investigation. And they're able to recover a surveillance video that captures the accused pointing something at the individual's back, taking the property, and then running away. So these would be all the different things that would be produced in what's called discovery. So discovery is the compilation of all the evidence that is produced that the prosecutor believes points to the guilt of the accused. And so the defense attorney would go over those videos with their client. If there were any photographs taken, go over the photographs, go over the witness statements, go over the police reports and everything, and ultimately say, hey, if we were to go to trial, this is the evidence that would be, put against you. Do you want to go to trial, or do you want to accept what's being offered? And so there's a whole host of reasons why a person may decide to, accept the offer or go to trial. I don't think that's really relevant to this video, but the point is that in order for the person to reach a decision to enter a plea, that's going to be preceded by the defense attorney going over with them any and all defenses that might have been available to them. So that's sort of a brief overview of, the way elements of a crime work, why they're necessary in terms of an analysis of whether a person should elect to go to trial or whether they should enter a guilty plea. And I think that will be helpful in being able to analyze and understand the future videos that I record. So just suffice it to say that once a person, decides to go to trial, then the prosecutor would have the burden of proving each and one of the elements beyond a reasonable doubt in order to have the jury find that person guilty. Otherwise, again, if they do not find that each and every one of the elements have been fulfilled or established, then there is no other choice but to find the person not guilty. So if you're watching this video, you may just be interested in criminal law. You may be a law student or a fellow attorney, or you might be in a situation where you've been charged with a crime and you're seeking advice or representation. If that's the case, and you're in San Diego County in California, we'd be happy to help. So you can give us a call at 619-399-3662. Again, that's 619-399-3662. The initial consultation is always free. I look forward to speaking with you, and I hope you enjoy the rest of your day. Until next time.